I am Jeff Rosen. I am the new president and CEO of this wonderful institution, the National Constitution Center. We have a mandate from Congress to disseminate information about the U.S. Constitution on a nonpartisan basis. To achieve that inspiring and unique mission, we have three goals. We are the Museum of We the People. We are America's Town Hall and a Center for Civic Education. And the program that I'm so pleased that you've joined us for today is very much in the spirit of civic education. It is so important, I think, to compare the approaches of different traditions and countries toward constitutional issues, and I can't imagine an issue that I'm more eager to discuss from a comparative perspective than privacy, and in particular to compare the Talmudic and U.S. constitutional approach to privacy. This is a topic very near to my heart. My first book about privacy began with a doctrine that comes from the Talmud, and I'll tell you a little bit more about it when we begin the substantive program. But the book was called The Unwanted Gaze, and the doctrine from the Talmud is called hezek re'iyah, or the injury caused by seeing, or the injury caused by being seen. And the strong dignitary foundation of Talmudic law when it comes to privacy is quite different from the U.S. Constitution's approach, which focuses more on the protection of private property and liberty. But I'll talk a bit about this, and joining me will be two acclaimed rabbis and ethicists who I'm so eager to introduce you to, Rabbi Mordechai Becher and my dear friend and teacher, Rabbi Shlomo Yaffe, who gave the best talk on the right to privacy, comparing the Talmudic and U.S. approaches that I've ever heard several years ago, and kindled my interest in this topic. We are going to be introduced, or rather we're going to be moderated by Jerome Marcus, who will ably lead us through our conversation. And before we begin it, I want to introduce our partner for today's program, the sponsor of this great event, and the gentleman who came to me during my first week on the job and said we've got to have a program comparing Talmudic and U.S. approaches to privacy, and that is Rabbi Alexander Coleman. He is the founder and director of the Institute for Jewish Ethics. In addition to his works with the Institute's seminars and lectures, he gives classes on Jewish ethics, spirituality, and personal growth. And we are absolutely thrilled to have him here today. Two brief bits of housekeeping. Please do take a moment to silence your cell phones before the event begins so we don't violate any Talmudic injunctions on modesty and dignity. And we will have time for Q&A, so if you have any, please write your questions down on a note card, and our wonderful staff will bring them up to our moderator, and we will engage with you. And now, without further ado, please join me in welcoming Rabbi Alexander Coleman. Rabbi Coleman. Thank you so much for coming. Please.
Thank you very much, Jeffrey, and the National Constitution Center. It's really a tremendous privilege to be able to partner with this very prestigious institute, a national icon honoring the Constitution and American history, even though I'm English, for those of you who know me. But it's really a tremendous privilege and honor to be here. It's equally a privilege to be associated with Jeff. I apologize for kind of interrupting the first week of your in calling you for that. But his reputation precedes him. Professor Rosen, aside from being the president and the CEO here of the National Constitution Center, he's also professor of law at George Washington University, and also appears on national television and radio. An author of numerous books, including The Unwanted Gaze, which he just mentioned, which the New York Times calls the definitive text in privacy perils in the digital age. So really it's a tremendous honor to be part of this gathering over here, addressing such a provocative and timely topic currently. Just very briefly, just to explain, the Institute for Jewish Ethics is the organization which I'm associated with, which I direct. Brochures are available to take a look at. But essentially, we present seminars and lectures addressing current issues from a Jewish perspective, a Talmudic perspective, and we have seminars which are accredited for CLE and for CME as well. Again, take a look at the literature, which will describe everything which we do. For this event, for this program, we have with us, as Professor Rosen mentioned, We have two experts, nationally and internationally regarded experts in Jewish ethics. Rabbi Becher, who's been I've had come to speak for us for many years now, and he's currently the adjunct professor of Jewish history at James Strike School of Yeshiva University. He's an author of several books, a prolific speaker across the globe on all things Jewish, and again, time doesn't really allow us to go through all the illustrious bios of the speakers, but in the brochure you'll see the descriptions of all the speakers. Rabbi, we also have with us Rabbi Shlomo Yaffe, who is currently the dean of the Institute of American and Talmudic Law and director of the Institute of Judaic Knowledge, and a good friend, an old-time friend of Professor Rosen. And so we're very honored to have him be part of the panel as well. And finally, a good friend, a dear friend of mine, Jerome Marcus, who is he's a senior partner at Marcus and Arbach law firm here in Philadelphia, also currently on the Kohelet faculty. It's a Kohelet faculty high school, specializing in his favorite subject of U.S. history. Also, he's an avid fan of the intersection between Talmudic law and American law, and that's why I asked him if he would be able to participate in this and be the moderator, because I felt he would really be able to bring out and kind of elicit the issues and the discussions which we're here to learn more about. So again, it's really a tremendous privilege. I'm very happy to be here and to participate in this, and I'm very excited. So thank you all for coming, and look forward to the program. Thank you.
Wonderful. Thank you. So nice to see you. What you want to sit in the middle? Yeah, absolutely. Great. You could just, as you please.
I think we're going to begin with Rabbi Becher, who's going to talk to us a little bit of the Jewish law perspective on the issues of privacy and surveillance. So without further ado, Rabbi Becher.
Thank you very much. Pleasure to be here. I am an Australian rabbi with Israeli citizenship, married to a wonderful woman from Philadelphia, living in New Jersey, teaching in New York. So, just to give you an international perspective on things. My wife and I spent a little over a week in the Soviet Union in 1985. That's just pre-Glasnost and Perestroika. We were at the Hotel Cosmos on Prospect Mira, and we were teaching Judaism, which at the time actually was illegal for us to do. And we were told by the organizers of our trip that we would be under surveillance. So we didn't really take this seriously. I grew up in Australia, my wife grew up in Philadelphia. Who takes this type of stuff seriously? They even gave us a little chalkboard with which to communicate in the room. And we come into the room, and I walk into the bathroom and notice there's no bath towels. So I said to my wife, I can't believe what a lousy hotel. There's no bath towels. About 5 minutes later, there's a knock on the door. Room service has got bath towels. Now, it is true that correlation does not prove causation, but it was suspiciously close to my rant that we got the towels, and that's what it was like. And naturally, every time we left the hotel, there was someone writing down when we left and someone writing down when we came back, and clearly that was a situation in a totalitarian state. But the truth is, we are always under surveillance in the modern world, whether it's something, well, you could call it benign, like Google Earth, or I remember walking in Jerusalem with my oldest son, Avraham, who was in the Israel military intelligence, and he said, you got your cell phone with you? I said, yeah. He says, take out the battery. And he takes the battery out of his cell phone, and I say, why are we doing this? And he says, because if you have the battery in your cell phone, even if it's off, we can pretty much hear anything you say. And I assume that if Israel has that technology, they've probably given it to the United States too, or rather vice versa. I don't know, Motorola is in Israel. But in any case, we know that there are such a thing as digital collection systems, DCS, which makes it fairly easy for government agencies to at least, not, if not legally easy, but technologically easy to gather information. There are software programs that can use your cell phone as a microphone, even if you have it turned off, as long as you have the battery in. There are all types of surveillance programs, certainly the internet. It's fairly easy. There's a splitter from the fiber optic cable carrying traffic across Atlantic, Pacific, etc. One half of the splitter goes into your computer. The other part of the splitter goes to government computers where it's stored. So, in any case, that's the situation we face. Obviously, fiber optics, internet, cell phones, and surveillance are not mentioned in the Talmud, which was completed in around 500, 600 CE. So we don't expect to find anything explicit about it, but we do find some interesting ideas. First of all, the most oft-repeated verse in the entire Torah, 5 books of Moses. What verse is repeated the most? You don't have to be a biblical scholar for this. You just have to know how to use the many search programs used on Jewish texts. So if you do this, you will find that the verse which is most often repeated, about 70 times, is the verse that says, "And God spoke to Moses to say." Vayidaber Hashem el Moshe lemor. And God spoke to Moses to say. So the Talmud, in classic fashion, the Talmud asks, if it already says God spoke to Moses, why do you have to add the word to say? I say word because in Hebrew it's one word. Why do you have to add to say? Just say God spoke to Moses and then give me what he said. Why now, as opposed to Charles Dickens, who, as we know, published his novels in piecemeal fashion in magazines and was paid by the word, we don't believe the author of the Bible was paid by the word. So he's very frugal in the use of words. It's a very short book if you take away the commentaries. If you add the commentaries, it fills this room. But basically, it's a short book. So why the addition of that word to say, So the Talmud says in Tractate Yoma, a fascinating idea. The Talmud says, this teaches us an important idea. It teaches us that every time God spoke to Moses, part of what he told Moses was whether he had permission to convey what he just heard. And the Talmud actually understands from here a rule in Jewish law, which is, if someone tells you something, you must assume confidentiality unless told otherwise. Someone has to say to you, to say, in order for you to convey it. As opposed to how we normally think. My guess is most people think, if someone tells me something, it's not confidential unless they tell me it's confidential. When they tell me it's confidential, then the next 5 people I tell, I say, by the way, that was confidential. But according to Jewish law, there's an assumption of confidentiality unless I am told otherwise. And the Talmud actually puts it almost as whether it is a biblical prohibition or not is unclear, but the Talmud puts it almost as a biblical prohibition to reveal that which someone else has told you. And so there's an assumption of confidentiality, and on the part of the one who knows the information, there is an obligation to retain that confidentiality. Privacy also, as we know very famously, one of the most beautiful descriptions or poetic descriptions of the Jews in the desert, Sinai desert, was given by Bil'am, non-Jewish prophet, who said the words, "Ma tovu ohalecha Yaakov," how goodly are thy tents, O Jacob. A lot of people have heard of that verse, the very famous verse. Many people say it whenever they enter a synagogue, how goodly are thy tents, O Jacob. But what was good about the tents? So Rashi, who was one of our great medieval commentaries, 1040, 1105. One of my kids came home from school once, said, "What'd you do today?" He said, "Nothing," which is usually true. But I said, "No, seriously, what did you learn about?" He said, "We learnt about Rashi." I said, "What'd you learn about Rashi?" He said, "We learnt that he lived during recess." So I said, "What are you talking about?" I said, what did the teacher say? He said, "Rashi lived from 1040 to 1105. So Rashi tells us, "How goodly are thy tents, O Jacob," is a reference to the fact that when the Jews camped in the desert, where we were, 19 years in Kadesh Barnea and other places, Middle Bronze Age, Interchange Period, etc. When we camped there, our tents were designed so the opening of one tent would not directly be across from the opening of the other tent. In order, although we were encamped in the desert, although we were on the move, although we were in temporary dwellings, but there was a care for the privacy of the other. And this as Professor Rosen mentioned, is enshrined in halakha, in Jewish law, in what we call hezek re'iyah, the prohibition against, hezek re'iyah literally means damage by seeing. Damage by seeing. There are many interpretations of what the damage is, but there's a damage by seeing, meaning I cannot, for example, open a window onto that overlooks a courtyard that you have been using for years for your private activities, etc. And there are many, many rules in the Talmud in Bava Basra that discuss the laws of neighbours and the restriction on privacy. And the truth of the matter is very interesting to note that even if the neighbour says, look, I don't mind, you can have a window, it's fine. In other words, what we call mochel, he forgoes his right to have the window. There are those who say, the Rashba from Spain, 13th century, the Ramah, Moshe Isserles, a scholar from Krakow in the 17th century, they say the following. They say, it may be true that he can forego his rights, but that doesn't mean that you now are free to look and to peer into his. In other words, his foregoing his rights and allowing you to build the window is not automatically an allowance and a permission for you to now check into his private matters. You still can't take out the binoculars, night vision scope, that type of, you cannot do that, right? So there's two aspects. Number one are his rights to privacy, and number two are your obligations to actually retain that privacy that he has. And it's interesting to note that one of the worst, throughout Jewish history, we find when Lot, we actually read about it, just read about it on this previous weekend, Shabbat, the Sabbath reading, we read about Lot being saved from the city of Sodom. And it says Lot was saved, the Talmud says he was saved he had some merit. What merit did Lot have? He was saved from this destruction of Sodom. So again, Rashi comes along and tells us that Abraham came to Egypt. He was very concerned that the Egyptians would kidnap his wife, who was very beautiful, which actually happened. And he was concerned about this, so he told them, and I won't go into the whole archaeological aspect of what the difference between a wife and a sister wife is in Sumerian society, but anyway, he says, she's my sister, she's not my wife, hoping that they wouldn't kill him to take her. So Lot, his nephew, is with them, and Lot kept his mouth shut. So Rashi says that was his merit. He was able to, he didn't reveal the secret. You know how it is, come back from, you're at customs and the form, and they say, were you not on a farm in the past 2 weeks? He says, oh, no, of course not. And the 10-year-old kid says, but Daddy, we were in that farm 2 days ago. Shut up, right? So Lot was quiet about that. And it's interesting that the Maharal, one of our great scholars, tells us that actually says there's a tremendous value that we place in Jewish tradition on what he calls pnimius, meaning that which is internal. He says the internal world we consider to be as important, actually more important than the external world. What's going on in private, what's going on within, that is reality. The external world sometimes is more illusory and temporary and not the reality. So he says Lot being able to understand, even at a young age, that confidence, keeping the confidence is important, is central to Jewish tradition and Jewish ideology. And to that degree, the Rashba says there was a community where people were not careful about these laws of hezek re'iyah, of damage by invasion of other people's privacy. And someone wrote to him and said, but that's the custom. Minhag, that's the custom. And the Rashba responded, he says, a custom that goes against the central ideas of Jewish tradition, that goes against confidentiality, that goes against privacy, that goes against the prohibition to search out other people's matters, he says, is not a custom. It's irrelevant. Actually, as Rabbeinu Tam pointed out in France in the 12th century, he says, custom, minhag, when you write it backwards, spells gehinam, which means hell. So so not all customs are fantastic. Just because it's a custom doesn't make it so. Also, I should point out just one second, or the penultimate point. Rabbeinu Gershom, we have a very famous decree of excommunication by Rabbeinu Gershom from quite the 11th century. Rabbeinu Gershom decreed that one is not allowed to read other people's correspondence. I think at his time there was maybe an increase in correspondence, postal service, etc., and he made a ban of excommunication on one who would read other people's correspondence. And some of the commentaries understand that the basis of that is a biblical prohibition, which is lo telech rachil ba'amecha, don't bear tales amongst your people. That is to say, you're not allowed to convey information, even if it's not explicitly damaging, but convey confidential information from one person to another. All Rabbeinu Gershom did was he applied it to letters, and he applied it to conveying it not just to someone else, but to yourself as well. So, as you see from the Jewish perspective, a Jewish perspective, I can't claim to be the Jewish perspective, but from a Jewish perspective, certainly confidentiality, privacy are very, very central, very important, both from a legal perspective and also from the spiritual perspective. On the other hand, of course, we know Judaism is very concerned with life and with saving of life, and certainly, we'll discuss this, the powers of a king, the powers of the monarchy, the powers of a government, and certainly the obligation to save life have to be taken into account. Just one more point is that Judaism is looks at law not primarily from the perspective of rights, but much more from the perspective of obligation, which is, as has been pointed out by Susan Lass-Stone, I think in an article in Harvard Law Review, she points out that's not merely semantics. See, rights focuses on what others owe me, are doing towards me, or are obligated towards me. But obligation is much more focused on what my obligations, etc. So therefore, sometimes, even if something may look at from the perspective of rights may be okay, but we have to look at it also in Jewish law from the perspective of obligation. It may be that I have an obligation to save life. I can't just stand idly by the blood of my fellow man. I have an obligation to do so. It's not merely a right that I have to intervene, but it's an obligation. And so that has to be balanced off against rights as well from the Jewish perspective. So I'm going to end here. I just wanted to give a very brief introduction. I feel I'm reminded of it was George Bernard Shaw who came when he was in the United States. He was asked to give a talk about a survey of English literature. And he said, "How long do I have?" They said, 10 minutes. He said, "How can I tell you everything I know about English literature in 10 minutes? They said, "Talk slowly, George." So thank you very much.
We've heard a perspective on Jewish law, which I think it's clear begins with the individual and the obligations of the individual, the rights of the individual. We're going to hear now from Jeffrey Rosen, who, as befits his post as the director of the National Constitution Center, focuses on the Constitution, which of course begins with state action and the regulation of state action, and we'll hear about the impact of the Constitution on privacy.
Wonderful. Well, first of all, thank you so much, Rabbi Becher, for a riveting, illuminating, and lively conversation. You started us off so well. And you talked about how in Jewish law the assumption is that conversations are confidential unless one is told otherwise and mutually agrees. Ladies and gentlemen, we are about to enter into a world in which technology means that the opposite is true, in which potentially all of our conversations in public spaces and private ones are recorded, sometimes without our knowledge, and potentially posted to the internet and archivable and searchable. So I was at a conference at Google not long ago, and the head of public policy at Google said he expected within just a few years, Google and Facebook would be asked to take live and online all the feeds from surveillance cameras around the world and post them online. He said that if this happened, it would be possible to click on a picture of anyone in the world, say me, back-click on me to see where I was coming from, forward-click to see where I was going, and basically have 24/7 surveillance of anyone in the system. And this seemed a little bit like science fiction. This was in 2007. But the science fiction is about to be increasingly fact because Google is about to introduce a new technology. They call it a cool new app, and it's called Google Glass. And Google Glass is a wearable camera and microphone that will allow me to walk up to you and be wearing these weirdo glasses, and we can start talking. You won't really know if I'm recording unless you look up and see the tiny blue light on the corner of my glasses. And increasingly, we will have to negotiate, even before I give this speech or we talk after the show, about whether or not the conversation is on or off the record. And the possibility that these Google Glass feeds, as everything is ubiquitously recorded, will in fact be archivable and stored, makes this prospect of 24/7 surveillance on Google all the more acute. And add that to drone technology, which is making it possible for police departments to mount tiny cameras that can fly in the air and track particular suspects from door to door 24/7. This possible of ubiquitous surveillance in public places is increasingly real, and the assumption that everything is private unless we agree otherwise may soon be reversed. So my question this morning is, how would Talmudic and US law approach the prospect of 24/7 surveillance on Google? Let's imagine that tomorrow Google announces that as an experiment, it's going to put all these camera feeds online so that anyone, fellow citizens or FBI agents, can basically click on pictures of anyone in the world and trace their movements 24/7 for a month. First of all, what would the Talmud say? Well, of course, the learned rabbis, my colleagues, know far more than I do about this, but as Rabbi Becher summarized so beautifully, this doctrine of hezek re'iyah, or the injury caused by seeing, would stipulate that even if I say it's fine with me if my neighbors trace me 24/7, I'm an exhibitionist, I like being tracked 24/7, the Talmud would object, I don't have the right to alienate that basic dignitary right despite my willingness to do so. The neighbor puts up a window in a common courtyard, and the window has to come down if I object, but even if I don't object, it comes down because even the smallest intrusion by the unwanted gaze causes injury, says the Talmud, because the injury caused by seeing cannot be measured. It's a fundamental offense against dignity, and just as I have no more right to sell my body into slavery or to sell my kidneys or to give up my dignity, the Talmudic dignitary tradition says I can't voluntarily accept 24/7 surveillance on Google. US constitutional law has a very different answer. First of all, as Jerome Marcus suggested, it's not obvious if Google were to put up this system tomorrow that the Constitution would even be implicated at all. After all, the Constitution only binds the government, and Google, despite its great power, is not the government. The Constitution, the Fourth Amendment, says the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. But that only binds the government, and although lawyers at Google have more power over who can speak and who can be heard around the globe than any king or president or Supreme Court justice, in their ability to remove or to leave up hate speech or other videos or controversial speech on YouTube, which Google owns, and on all their Google search engines, nevertheless, a court might hold Google as a private corporation, and therefore the Fourth Amendment doesn't apply at all. Now, let's assume for the sake of argument that the Fourth Amendment does apply, because maybe Google is doing this with government money, or maybe the NSA or the FBI are using this Google system to trace suspected terrorists 24/7. So the courts might say there's enough state action, as the lawyers say, to implicate the Fourth Amendment. So let's assume the Fourth Amendment applies. Would the Supreme Court hold that this 24/7 Google system violates the Fourth Amendment? Well, the most relevant decision on the matter was handed down by the Supreme Court 2 years ago, a fascinating case called United States versus Jones, involving GPS, or global positioning system surveillance. This is a case where the cops suspect someone of dealing drugs, and they put a GPS device on the bottom of his car without notifying him, and trace his movements 24/7 for a month. Based on this surveillance, they conclude he is indeed dealing drugs, he's indicted and convicted, and he objects and says the GPS evidence should be excluded because the cops didn't have a valid warrant before they put the device on the bottom of the car. In fact, they did get a warrant, but they were supposed to start following him within 10 days, and they started on the 11th day. They were supposed to only follow him in DC, and in fact, they followed him in Maryland. So for the purposes of the case, the court had to assume there was no valid warrant, and the Obama administration made the issue even starker by taking the position that no warrant is necessary for 24/7 surveillance in public because we have no expectation of privacy in public. A little murmur there. It's the opposite of the Talmudic assumption, which is that privacy and dignity can't be alienated. The Obama administration, citing some lower court decisions, said we have to assume the risk anytime we walk out on public streets that we are being tracked 24/7 by our neighbors or by the police. The Supreme Court, in a fascinating and to some surprising decision, unanimously rejected the Obama administration's claim. But it did so for reasons that might not constrain this 24/7 Google system. 5 justices, led by Justice Antonin Scalia, focused on invasions of private property. Scalia said the cops had to physically affix the GPS device to the bottom of the car and also trespass on the guy's driveway in order to put the device on. And at the time of the framing of the Constitution, said Scalia, even the smallest physical trespass for the purpose of collecting information would have been considered a search, said Scalia, and therefore a warrant was presumptively required, although he didn't dispose of that question finally. 4 justices, led by Justice Samuel Alito, would have gone further. Alito noted, focusing on physical invasions of property make no sense in the age of the internet, because after all, the cops could have gotten the same GPS information by subpoenaing the LoJack device that was embedded in the guy's car, or they could have simply subpoenaed his cell phone records. All of us are carrying around with us in our smartphones walking GPS devices, and by issuing a subpoena to Verizon or whatever my company is, it would be possible to get all of the geolocational records that would allow the reconstruction of my movements 24/7 without physically affixing the device on the bottom of the car. So Alito's test was different. He said, we do have an expectation of privacy in the whole of our movements because 24/7 surveillance for a month can reveal so much about us. The political rallies we attend, or the friends we associate with, or the bars that we visit, that citizens don't subjectively expect to be tracked to that degree. So these are 2 very interesting holdings. But they don't give us a clear answer to the constitutionality of my 24/7 Google scenario. First of all, in the 24/7 Google tracking scenario, there's no physical trespass. The cops don't have to affix any GPS devices to the bottom of anything. They just take the archived feeds from Google Glass and from flying drones and access them. So if you're going to focus on physical invasions of private property, I have no protection against being tracked 24/7 in public by Google surveillance. Alito's test seems a little more promising. Bless you. I might say, I have an expectation of privacy that when I walk out on the street, I'm not going to be tracked 24/7 for a month. But that expectation is contingent on technology, and if Google announced tomorrow, we're going to start putting all the feeds up, get used to it, or more to the point, if the norm soon develops within 5 years, as it might, that whenever we talk and you're wearing Google Glass and so am I have to assume the risk that I'm being recorded unless we explicitly negotiate that I'm not, then my subjective expectations of privacy would diminish along with my constitutional protections, which is why many people feel that this Supreme Court test for privacy, what do people subjectively expect, and is that expectation objectively reasonable, is too contingent on the technology in general use and doesn't provide the solid dignitary protection that something like Talmudic law would. There's one more argument that might be invoked under current constitutional doctrine to constrain 24/7 surveillance in public, and that is the right to privacy and autonomy recognized in cases like Roe versus Wade. In affirming Roe, in the Casey case in 1992, Justice Anthony Kennedy said, "At the heart of liberty is the right to define one's own conception of meaning, of the universe, and the mystery of human life." And in striking down sodomy laws in the 2003 Lawrence case, Kennedy repeated that privacy has both spatial and more transcendent dimensions, and the state may not demean gays and lesbians, that was his word, or constrain their autonomous choices to choose their intimate behaviors. So this rather sweeping conception of autonomy might be invoked to say when the state tracks me 24/7, I'm more inhibited, less spontaneous, and less able to define my own conception of meaning and the universe and the mystery of human life in a way that threatens my autonomy rights. The trouble is that's pretty highfalutin stuff, and as you know, the Roe v. Wade privacy right is criticized by some, not only pro-life conservatives, but other, even some pro-choice liberal scholars who think its constitutional roots are a little bit amorphous, and it's a rather sweeping way of going at things. So I wouldn't bet on a majority of the court invoking this right to autonomy to constrain Google. There's one other way of attacking the problem, and this is the final argument on which I'll close. Europe, it turns out, is much closer to the Talmudic than the American tradition. There's a beautiful article, the best comparative article on privacy I've read, called Two Conceptions of Privacy, Liberty versus Dignity. And it compares the American approach, always rooted in notions of private property and liberty, with the European approach, which is focused more on notions of dignity and honor. And in Europe, in the 19th century, if someone insulted you, then if it was your social equal, you could challenge him to a duel. And if it's your social inferior, you hit him with a cane, and you choose the wood of the cane to signify the social status. So a low-status person gets, I don't know, hickory, and a high-status person gets cherry wood or something like this. And you could only run an honor-based system like this in a very hierarchical world where everyone knew their place. And those notions of honor were democratized in the 20th century. So today in Germany, if someone gives you the finger on the highway, you can sue. Imagine how that would fare in California. And this European dignity-based notion, tied up in ideas of aristocratic honor, which have been democratized, is embedded in European privacy law. So the German constitution sweepingly protects a right to dignity that looks a little bit like the right of Hesekria. And this is the lead, the punchline. The European Union is currently debating whether to invoke a sweeping incarnation of this dignitary right called the right to be forgotten. This comes from the French law, the droit à l'oubli, or the right of oblivion. And this is very French, obviously. Americans all want to be remembered, and French want to be oblivious, like something out of Sartre. They want to blot themselves out. But this right to be forgotten, if codified by the European Union, would give any data subject the right to demand the removal of any data concerning him or herself, period, unless a European privacy commissioner decided in retrospect that it was necessary for literary, scientific, or journalistic purposes. So, for example, not only would I have the right to demand the removal of a picture that I posted myself on Facebook after this talk, but if you go out and blog that I gave a boring presentation at the National Constitution Center, I could say that this offends my dignitary rights and my right to be forgotten, and Google and Facebook would face fines of up to 1% of their annual income, which in Google's case last year was $40 billion, unless a European privacy commissioner in Dublin or somewhere like that decides that your blog posting was necessary for journalistic, scientific, or public interest. You can imagine that lawyers at Google are very anxious about this regulation, and as an American constitutional lawyer who cares deeply about privacy, but also cares a lot about free expression, I have to say that given the choice between these two values here, my free expression knee jerks harder than my privacy instincts. And I think that this is very antithetical to the American tradition, which generally holds that the publication of truthful but embarrassing information may not be constrained without evidence of falsity or actual malice. So this is being worked out now. The regulation may or may not pass, but it just shows how timely and important our discussion is and how much more comfortable Europeans are, first of all, with notions of dignity rather than liberty. And as our moderator said, Europeans are much more inclined to constrict data gathering in the private sector for dignitary reasons. Americans, which have an anti-statist tradition, which unites Tea Party conservatives with civil libertarian liberals, are more willing to constrain the state. But for far more deep and illuminating background on this clash between dignity and liberty, I'm now delighted to welcome, and I'll let Jerome Marcus welcome, my dear friend and learned colleague, Rabbi Yaffe. Thank you so much.
Rabbi Yaffe, as I recall, the discussion in Baba Basra about Hezek Re'iyah revolves around a courtyard. And it strikes me, listening to Mr. Rosen, that a courtyard is a funny place because it's a shared courtyard. So it's not completely private, but it's also not completely public. In some ways, it's sort of a mixture of the two. And I wonder if, starting from that point, you can explain to us how the Talmud responds to the sorts of issues that Jeffrey has been laying out for us.
Well, first of all, the status of the particular courtyard in that text is dealing with the question of the fact that people use their courtyards as quasi-private places of family life. In other words, the shared courtyard, you have the right to force a partition to be built in the shared courtyard because you have a right to private family time in your courtyard. So the courtyard was primarily a private space, but a space that wasn't as private as the interior of the home, which actually leads to a distinction that the Nemuke Yosef, who lived at the beginning of the 14th century, makes, and that to something that Rabbi Becher had mentioned, that even if someone forgives you, allows you, and says it's okay if you put windows up, that's true. And and as Rabbi Becher pointed out, you can't just look in anyways. But nevertheless, what's really interesting is that the Nemuke Yosef says that's only true of a courtyard, which is quasi-private space. But if your window is facing someone's house, you may, even if that person says it's okay, you can put a window facing my window, you're not allowed to, because you're not allowed to have the temptation or the ability to look into someone's most private space, even if that person is an exhibitionist, as if it were, as we heard before. So the courtyard is almost private space. That being said, the other issues about privacy, which relate, for example, to the question of rechilot, of tale-bearing, and as Rabbi Becher pointed out, the acquisition phase is as prohibited as the dissemination phase. If you are going to gossip, you first need to acquire material to gossip. And the acquisition phase is prohibited, Rabbi Chagiz says, just as the dissemination phase. So in that context, that does not have to do with an assumed right of privacy in space. That's a fundamental obligation for me not to interfere with a individual's privacy. And so it's not merely about space. With that in mind, I wanted to comment about a few things that our first two speakers said. One is that, as you heard, the Talmud dates to 500 CE or so the drones are not in the Talmud. But the Talmud likes engaging in thought experiments. In other words, the Talmud is concerned with the broader underlying ideas. That is why Maimonides derives from the Talmud a prohibition against murdering someone to heal yourself, which even in Maimonides' times was impossible, but with all these accusations flying around about organ farms in countries without civil liberties, all of a sudden, this concern the Talmud had articulated by Maimonides, so a concern in the 4th century articulated in the 13th is frighteningly a problem today, where where in some places apparently people are being murdered to harvest their organs that someone else with money should be able to live. I mention this in that with regards to the laws of Sabbath, the laws of Shabbat, there's a discussion about different types of domains. And one of them is the so-called private domain, which is not an ownership issue. It's a issue of the type of space. But it says that this domain reaches till the firmament. It reaches till outer space, that you have air rights all the way up. And several commentators make the point that this is true about people's trees, this is true about anything I do at whatever altitude that interferes with my air rights. So even though almost no legal system at the moment has a law about drones, flying drones over your house, the fact is that the right to privacy in my courtyard, which is quasi-private space, would seem to be protected, that no one can fly a drone into my space that reaches the heavens unless I have permission. This hasn't been tested yet in any rabbinic court I know of, but it would seem to be the case because there's an argument of whatever right you have at the ground level in the courtyard, you also have at any altitude. Last of all, about this debate between Europe and the United States that Professor Rosen raised, and the question of dignity versus privacy, there's a very interesting way, and the Talmud does this a lot, but Talmudic law, in a sense, splits the difference when it comes to issues of libel, and we can extend this to issues of privacy, in a sense. On one hand, as we know, one of the most serious prohibitions in Jewish law is slander. Not just tale-bearing, as we discussed, disseminating private information, but speaking ill of someone. Even if that which you speak ill of them is true, you're still not allowed to. And the only excuse is to save someone from financial loss, from bodily harm, and so on. So what's really interesting is that in spite of the thousands of pages written about how horrible Lashon Hara, how horrible slander is, how horrible Rechilot is, on the tale-bearing is, on the whole, there is no criminal sanction. There is no fine, there is no punishment other than the punishments that courts can apply as if it were what they call in England anti-social behavioral orders. In other words, only if there's a reason because society is being affected, you can impose a one-off punishment. But there's no standard punishment. And it seems to me the reason is, as several, this language appears in several responses, several interesting halachic decisions, that just like it is a great sin to speak ill of someone where it's forbidden, it is a great sin not to speak ill of someone where it is in the private or public interest. So if we were to put sanction, if you could sue someone for libel, as in England, we know that in the United Kingdom there's a terrible chilling effect on things like child abuse and all kinds of political and financial bad behavior because of the fear of a libel suit. And the wealthy person with a battery of solicitors is able to impose their will and frighten away the citizen who may have an issue. So Jewish law says, look, this is a huge issue, but it is between ultimately yourself, the society you live in, and the Almighty. We will impose no sanction because we do not want to chill your ability to acquire information and disseminate it if indeed it is necessary to save someone's life, dignity, and so on and so forth. So it's interesting how in its practical application, Talmudic law splits the difference between both approaches, and it seems to me reaches sort of the perfect golden mean in this area.
So let me take the conversation in a slightly different direction. One of the issues that seems to me that has been sort of floating around here is the question of consent. We're all familiar with downloading a piece of software, and one of the things that pops up at the beginning is, do you agree to the license, which no rational person would ever actually sit there and read. So, but who knows what's in there? I actually have had, because I'm a lawyer, I've actually had to read them sometimes, and they speak sometimes about the extent to which the things that you do with that software package are going to be recorded, used, sold, disseminated, and when you click I agree, you've agreed, you've consented. So one thing I'm curious about is both from an American law perspective and from a halachic perspective, to what extent is there consent? Is there consent if you're out in public? Is that consent if you're walking the streets of London, which I think has a camera every XDX feet? Have you consented to be filmed? Have you consented if you're standing in front of the person with Google Glass? If you have left the Reshut HaYachid, the private domain, and gone into a public domain, have you, by doing that, consented to being observed? How do these two different systems approach that question?
It's a wonderful question, and it's central to the current constitutional debate. The American doctrine is called assumption of risk, and basically the idea is that when I go out in public, I have to assume the risk that if I turn over data to a third party, that third party may turn it over to anyone else. And those two notions, that I assume the risk and that the third-party databases can share the information, basically mean the end of privacy in an age when all of our movements are recorded and stored by third parties. And Justice Sonia Sotomayor, in her concurrence in the Jones case, said unless we re-examine both this assumption of risk doctrine and the third-party doctrine, then there will be no privacy in public places. I find the assumption of risk doctrine practically unsatisfying for the reasons you suggested, and also constitutionally inadequate. So in practice, yes, as you say, everyone just clicks through the privacy policies. I'm supposed to be a privacy junkie. I don't read the darn things either. And I don't think that it's a meaningful choice to be asked to assume the risk. So if you work in certain government jobs, your computer, when you turn it on, will say, I understand that everything I am doing on this computer may be monitored. And maybe that's appropriate in the context of a government computer. But it wouldn't be okay for Mark Zuckerberg to go on Facebook and say, hey, we've got this cool new app called Open Planet. You can check up on your friends by walking on the street. You consent to be viewed on Open Planet. it's not a meaningful choice. It's not realistic to expect me either to live like a hermit or the Unabomber and never to turn on my computer or go out in public, or to assume the risk that everyone is.
But why is, for example, why would, and I don't know what the presumption is, and I may, as my children tell me, be the only person in the universe that doesn't have a Facebook page, but
Very wise.
What is the implication of saying, well, here's this wonderful device, Facebook. It facilitates all these terrific, allegedly terrific things that you can do. And if you go on this, you are consenting to fill in the blank. Having every move that you make on Facebook recorded. If that's what he wants to say, why is that wrong?
Let's distinguish between the constitutional answer and the
Contract
ethical answer. Facebook and Google are quasi-public utilities. Basically, to live, you don't have to be on Facebook, thank God, to live as an engaged citizen, but you can't really not use Google. It's not a meaningful choice. Or it's not realistic to say, don't go on the internet. So therefore, if Facebook and Google are architected in ways that make them impossible to use unless you accept onerous and illiberal conditions that require the total surrendering of your privacy, then we will, as a practical matter, have less privacy in the age of Google than the framers of the Constitution took for granted. The solution to that might not be a constitutional one. It might require a statute. And on a very simple level, there is a bill pending in Congress that would require Facebook and Google and the phone companies to get a warrant or to be presented with a warrant before they turn over geolocational information to the government. So there's a small restriction of the assumption of risk doctrine, and this bill, co-sponsored by Josh Chaffetz, a Tea Party Republican, and Ron Wyden, an Oregon ACLU Democrat, would basically say, which is a wonderful group of bedfellows, would basically say that you can't turn over the information. So that's basically my answer. It doesn't make sense to me ethically, normatively, or practically to say I'm assuming a risk.
So I want to seize on something that you didn't say. You talked about the constitutional way of understanding it and the ethical way of understanding it. You didn't talk about the contractual way of understanding it. I'm a little surprised about that, but I'm curious, to what extent does halacha allow someone to say, I mean, you've touched on this already, both of you, I consent, or I don't consent, or we don't care whether you want to consent or not? How does halacha approach that problem, either in the public domain or in the semi-private domain or the entirely private domain?
Just a few points there. I mentioned that the authority, the Rashba, points out that even if one would consent to allowing the window over the courtyard, this does not automatically allow the observer to now stand there and stare. Maybe if he's walking by and he looks out, that's one scenario, but the scenario in which he is actively trying to investigate his neighbour, that it does not help that his neighbour consented, because he has, again, it's not only a matter of the rights of the neighbour, it's a matter of his obligation to preserve dignity, in the European sense, privacy, and what we call in Hebrew tzniut. So therefore he's still got this obligation upon himself.
Tzniut
means privacy or modesty. Right? Lahat tzniya in Hebrew means to put something away and preserve it. So the preservation of people's privacy and dignity, etc., is considered a paramount importance. On the other hand, there are situations, for example, as Rabbi Yaffe mentioned, there are the laws of what we call lashon hara, slander, and the conveying of information, dissemination of information. The Talmud says that something which a person said in the presence of three people can be assumed to be public information, and which means when I disseminate that, as long as I don't have malicious intent, something only known to God, but as long as I don't have malicious intent, dissemination of information which he said, in other words, standing in the office at the water cooler, they still have those, right? Water cooler, and he says, by the way, I'm planning on moving to California, and there's three of us there. I am allowed to convey that information because it's already considered public once he has said it, as the Talmud says, ba'ape tlata, in the presence of three people. So that would be an assumed, I guess, consent. He said it in front of three people. By saying it in front of three people, he obviously has said, this is not confidential. Had it been confidential, he would have taken me aside, for example. It's interesting also, just was thinking of one more example, is the Minchat Chinuch of the 18th, maybe 19th century. He points out that you can convict someone on the basis of hidden witnesses. Obviously, they didn't have bugs, microphones, etc., but you could have people hiding behind somewhere and observing someone. And he says a Jewish court would be allowed to convict someone based on hidden witnesses. In other words, we wouldn't have the idea of a certain, you'd be allowed to, and the court would be allowed to actually put hidden witnesses in place if they suspected someone of a crime, even without, since we don't have an idea of a constitution, we don't have a search warrant requirement there. Although, just important to point out, Jewish law does recognize that there's a dual justice system, meaning even in a classic Jewish state, when there was a monarchy, there was also a Sanhedrin, the Jewish court. And while the court would judge based on strict Jewish law, the king had the right to enact laws that were in the grey areas that Jewish law does not directly address. So, for example, if the king would require search warrants, then the Sanhedrin would support that. If the king would, for example, accept circumstantial evidence, even though Jewish law generally only accepts testimony, the king would be able to do that. So in terms of modern times, we would probably allow, like in the Israeli government, for example, there are laws in Israel of what's called chok pratiyut, the law of privacy, which actually does, again, require a person's consent before his private details are put under surveillance or are published, for example.
Could I respond very briefly to those fascinating examples from the U.S. perspective? So the hidden witnesses, the analog is the cases that say it's okay for the cops to have an informant with a hidden microphone and to broadcast that to the world because we assume the risk that when we're talking to a friend, it's a false friend and they're going to share the information. But that case, the United States versus White case, raised a spirited dissent from Justice John Marshall Harlan, the guy who'd come up with the expectation of privacy test, and he said, it's not right that we should all have to assume that we're living in a police state. The proper question is, how much exposure should citizens in a free society be expected to bear? That it's a normative question about how much privacy is necessary, and that leaves it up to judges to decide whether or not the broadcast could take place. On the Lashon Hara, I'd love further illumination from my colleagues, but is it right that even if you don't say the truthful but embarrassing tale-bearing in the presence of three witnesses, every single word we speak ascends to the heavenly clouds and is recorded there? Of course, the Google cloud has made this metaphor literal. And if I say something nasty about someone else and only one person hears it, it's recorded by God in heaven, and I have an obligation to go to that person face to face and ask apology. And if I ask 3 times, then the apology is supposed to be accepted. But the Talmudic solution there is not a legal one. The information has to come down. It recognizes it's more offenses between men and men or women and women have to be atoned for on an individual basis, and we don't expect law to solve that for us.
So I think there's someone collecting questions from the audience, but while those, if there are any, I hope there will be, while those are brought up, let me raise another issue, which I'm actually surprised has not come up more, and that is when I was initially told about the subject of this panel, I expected it to focus, at least to a significant extent, on government intrusions into our personal space. And I was thinking about that from the perspective of, as a lawyer, we all know the Fourth Amendment, and we have some understanding of the extent to which the state is constrained, but the extent to which the state under halacha is constrained, it seems to me, is a much more difficult question to wrap one's arms around. Actually, I was thinking in the context of what you were just discussing, that how does the hidden witness rule interact with the rule requiring a warning before one can be charged with a crime, at least a crime that's going to be prosecuted in a Beit Din? There has to be a warning in the presence of 2 witnesses. So if the hidden witnesses are there, I don't know how that fits. But I'm just curious the extent to which the concept of privacy, how does that interact with the role of the government authority, the halachic authority, whether it's the Beit Din or a king or whatever is the source of halachic law enforcement and interpretation? How does privacy fit with that? Or if either of you wants to speak to it.
So I think that one of the very interesting aspects of this is something that you actually raised in an email, which is that there are a lot of things that are violations of Jewish law that in a Judaic commonwealth would be seen as deeply problematic, But nevertheless, because they take place in the privacy of one's home or in a space where we don't have witnesses or the like, we don't see anywhere that the Beit Din is obliged to engage in the rabbinic courts, and the monarchy for that matter, are obliged to engage in a process as if it were of prying and spying and so on and so forth. A lot, and quite frankly, even in the realm of slander we spoke about, Jewish law leaves a lot to the individual conscience. It understands, in Massachusetts, there used to be a rule for criminal insanity called the policeman at the elbow. If you would commit this act with a policeman at your elbow, then you're insane. If you wouldn't, you're not insane. But what's interesting is that any society that builds itself on getting people to behave properly because there's a policeman at their elbow is doomed to failure. As you know, the obligation to study Judaic law and Judaism, everyone needs to be a lawyer. That's why so many Jews are lawyers, because it's deeply ingrained in Jewish tradition. Everyone must study the law, everyone must know it, and penalties and criminal sanctions and all that are a last-ditch resort. The idea is that we all actively have to be engaged proactively in living a life according to the law. So Judaic law is not a response to societal problems or issues. It is a proactive blueprint for how to create the optimal possible society. And therefore, we leave a lot to the individual conscience. And so I should make the point that there actually is very little assumption of any kind of prying and investigation and so on. That being said, it's clear that we are obliged to prevent harm to the community and the like. But even there's a strong sense of limits. And I'll share with you a question that actually came to this same Rabbi Chagiz I mentioned before, and it was a strong legal question. And this came to a Beit Din, to rabbinic court, which by voluntary acceptance in the 19th century, 18th, 19th centuries, had a lot of power within a Jewish community by voluntary societal acceptance, as we know. And the question was that someone came along and said, look, there is a letter that I have in my hand, because letters used to be passed from merchant to merchant. I have this letter. I believe that it has nefarious plans of a swindle, a personal harm that A is trying to impose on B. May I read it to find out? Should the court read it and decide whether there is a subversion to engage in some criminal activity? So what Rav Chagiz ruled was that there is insufficient evidence to allow me or you to invade this individual's privacy. Because again, it's a personal obligation. However, because there is a suspicion based on the previous activities and reputation of the individuals involved, to be concerned that this letter is poisonous, as if it were, that it's a ticking bomb. So he says you may destroy the letter. So in other words, even where we're concerned about a possible damage, nevertheless, that doesn't mean that we can wholesale walk over the rights to privacy. It is all in very, very precise measures. And this is, I believe, how, if Judaic law was given a government to run, how it would approach in extremely subtle slices where we have the right to concern ourselves with a societal threat, but that doesn't mean that that right enables me to read everyone's mail and absolutely everything that's out there. And I would add one other point, that with regards to informed consent that we were talking about before, that no one has the right to make themselves exposed to the world. The Talmud says that someone who doesn't allow the obligations of privacy to descend on them, people who allow their privacy to be violated and trampled on, or do private things in public places and so on, such people are invalid to sit on a court or even for their testimony to be accepted in a court of law. because the obligation to respect others' privacy is equally true. Love your fellow as yourself. As yourself, you need to respect your own dignity and your own privacy. And therefore, I think there's a very basic assumption that anything that is a violation of what we consider the core values of a person's tzniut, modesty, personal space, and the like, there can be no informed consent for it, because that's a fundamental right that we cannot waive or obligation, even for ourselves, just like society doesn't let us harm ourselves and will involuntarily commit us if we seek to harm ourselves.
Here's a question that I think requires a very different perspective on what we've been talking about, but I think it's a fascinating question. That is, what is the teaching of the Torah, and by extension, the teaching of American law, on the privacy of leaders? Leaders.
Well, I can start with the U.S. answer because it's easy enough, which is that they don't have much. That basically, ever since Justice Brandeis, the greatest theorist of the right to privacy of the 20th century, as well as the founder of the American Zionist movement and my personal hero, and the justice whose bust sits in my office, and whenever I face a hard question, I ask myself, WWBD, what would Brandeis do? He stumbled on this question because in his great article on the right to privacy in 1890, he tried to suggest that there were some forms of invasion that even public figures shouldn't have to endure. And the example he gave was the time of day that a man dined with his wife, and said that even a public figure shouldn't have to have that exposed. Basically, courts, in trying to apply the Brandeis torts, which sound like a yummy dessert but are actually a confusing and unsatisfying area of law that turn on what kind of invasions people would find highly offensive to a reasonable person, stumbled because they couldn't agree about either what was highly offensive or exactly what, how much, basically what people should be interested in when it came to the lives of public figures. And as a result, American law in the post-First Amendment age, which really ramped up in the 1960s, basically said as long as the publication was not with malicious intent or actual malice or negligent disregard to the truth of the matter, if it was truthful but embarrassing, public figures couldn't object. So unlike France, where a law review article once said the Brandeis torts are alive and well and living in France, and where the royal family can sue when someone takes a bikini picture of them on the beach, in the US, the presidential family could not sue unless it was tortious and highly invasive, because basically public figures are put in a separate category. Private figures have a little bit more protection against truthful but embarrassing speech, but leaders, aside from libel or tortious invasion, are essentially out of luck.
And that's true not only for people in an official government position, but just anybody who's famous. Elvis can't, or couldn't when he was alive, he would be subject to the same constraints, would he not?
Any public figure, and the test for a public figure, it's very evocative. Have you thrust yourself into the vortex of public debate? That's what the Supreme Court said. And now that everyone with a modem or a Facebook page can thrust themselves into the vortex of public debate, and we all have our Andy Warhol 15 minutes of fame, the distinction between public and private figures is being eluded, and it's not really clear that anyone, fewer and fewer people can claim to be entirely private as a result.
So how does Jewish law approach the question of the privacy of its leaders?
I'm not actually familiar with any particular exemption from the laws of slander or lashon hara, for example, for a public figure. There's actually an interesting contrast which was drawn by Rabbi Yosef Albo between King Saul and King David. Both of these kings committed sins. King Saul committed a sin of omission by not making warfare in an appropriate manner against Amalek. Amalek was the ancient version of Al-Qaeda, Al-Aqsa, Hezbollah, Hizbul al-Tariq, KKK, and the Nazis all rolled into one. So either way, King Saul failed in his mission in a war against Amalek, and as a result, the prophet Samuel basically predicted that he would be removed from being the king, and his descendants would not inherit the monarchy from him. Contrast this, Rabbi Yosef Alba contrasts this with King David. King David very famously, as you mentioned in the email, King David had an affair with Bathsheba, who was married to Uriah the Hittite. And granted, the Talmud says that there was customary to give a divorce before going to battle in case you would disappear or be captured, etc. But nevertheless, Uriah came back. King David sent Uriah back to the front lines. He was killed, and King David marries Bathsheba, his widow. Now, what happens is the prophet, very famously prophet Nathan, comes to King David and tells him, he says, there was a man with only one sheep, very poor, and his rich neighbor, who had an entire flock, was fabulously wealthy, killed this man and took his sheep. What would you say about this man? King David said he's a thief and murderer, he's evil, and Nathan the prophet says, you are that man. By the way, in Jewish tradition, we always had prophets whose job it was to basically criticize, yell at the king. So there was this, so this is what Nathan says. King David's reaction was, I have sinned, and as a result, it's interesting, King David was punished. His son from that marriage died under tragic circumstances in the midst of a rebellion against his father. Terrible punishment. But what is significant, as we know, is that King David did not lose the kingdom. Neither did his descendants lose the right to the monarchy. What is the distinction between King Saul, who did a sin, King David did a sin? One loses the monarchy, one does not. Both punished. King David's punished, doesn't get away with it scot-free, but he's still punished, but he doesn't lose the kingdom. One of Rabbi Yosef Alba's answers is that King Saul tried to excuse himself, did not admit to it immediately, blamed the people, gave religious explanation, and only after 3 or 4 times did he say, yes, I sinned. King David immediately admitted to it, one possibility. The other possibility, he says, is that King Saul's sin was committed in his role as king in the public domain, meaning his role as king is to lead the people in war and to protect the people from their enemies. King David committed a sin, but it was in his private life. So it was a sin, and he was punished in his own private life, in his family, but as far as his public role was not affected, and he continued as king. So it would seem to indicate that the privacy and the private life even of a leader is still considered somewhat separate from his public life, and would reinforce my belief that probably these laws would still apply to a public figure as they would to any private individual.
Well, I would just add that it's clear from Tractate Sota in the Talmud that King David's indiscretion, perhaps because of the prophet's admonition to him, was public knowledge, and there were people who were very critical of him, and basically his response was, yeah, I did wrong, I repented, but what about you who are slandering me to no further purpose? But what we derive from there, I think, would be fair to say that had he brazened it out, had he not repented, he would have been unfit to be a king. We see this with King Ahab, with Ahab, the husband of the famous Jezebel, who engineered a false court case to murder Nabot, who owned a vineyard that he wanted. It's a very famous story in the book of Kings. And Elijah appears and says, that's it, your monarchy's done, and you're going to die, and that's it, it's over. And interestingly enough, he was an idol worshiper and did all kinds of other inappropriate things, but he lost the monarchy over this, because he committed a sin against another person, abused his power, but did not repent. And it's very clear that anyone who has a pattern of inappropriate private behavior, either on a personal level or monetarily, and does not fix those things and continues to exhibit this pattern, we have to remove this person from public office. And the point of this is and this is true of the Sanhedrin, of the Supreme Court, and of all the lower courts, if someone's behavior is consistently bad and the pattern is not negated, you have to remove the person. And if you have to remove someone, you have to also be able to acquire the knowledge to engage in that removal. So it does seem to me that there is a slightly larger scope for the dissemination and acquisition of negative knowledge about a private figure about a public figure, a leader, than there is a purely private figure. Why? Because we believe that a person who is morally and ethically compromised, no matter how skilled and how charismatic, cannot be the kind of leader that the Torah advocates we need to have. Because leadership is first moral, first ethical, first religious, then competency comes last. If you look at Maimonides' list of the qualities that a member of the Sanhedrin needs to have, and this was the Supreme Court and legislature of the ancient Jewish Commonwealth, the first number of qualities, 4, 5, 6 of them have to do with integrity of character, and wisdom only comes after those, and knowledge. So I think this is an important aspect of this too.
So let me end with a jurisprudential question, which was bothering me and is manifest in several of the questions. On the one hand, we have the Fourth Amendment, which was written when people wrote on parchment with quills. On the other hand, we have the Gemara, which was closed in the 6th century. It's been added to with responsa, but even the vast majority of those were finished long before people got to quills and parchment, or at least long before people got past them. So from a jurisprudential standpoint, how in these two different systems, how do we go about adapting the law, the legal system, the rules, in order to apply them to a world where, as one of the questioners said, instead of worrying about whether someone's going to hit you on the head with a rock, we're worrying about whether someone's going to take a vial of sarin and dump it into a body of water and murder an entire city?
Wonderful question. Once again, WWBD. What would Brandeis do? He addressed this precise question in his great opinion involving wiretapping. And here's how he addressed it, and his guidance is so illuminating today. The question in this case, the Olmsted case, 1928, involves, can the police put a wiretap on the wires in the sidewalk leading up to the office of a suspected bootlegger and listen in on his conversations? And they did that, and they found out he was indeed illegally transporting booze. This is the height of Prohibition. In fact, Olmsted's telephone was displayed in our wonderful Prohibition exhibition, which just was here last year. Beautiful exhibition and a thrilling artifact to actually see the telephone. The guy was convicted, and like Jones in the GPS case, he said the evidence should be excluded. There was no warrant. In a wooden, formalistic opinion, Chief Justice William Howard Taft, the former president, rejected the claim on grounds that sounded very much like Justice Scalia. He said no physical trespass, no Fourth Amendment violation, because the cops didn't have to trespass on private property or break into the guy's office, but could just tap the wires under the sidewalk. There was no private property invasion, and therefore the guy was out of luck. In his visionary dissenting opinion, Brandeis disagreed, and here's how he answered the question. First, he identified the paradigm case that the framers of the Constitution were concerned about protecting against, not the technology of quills or the technology of invasion, which was breaking into someone's home, but the story of John Wilkes. This is a critic of King George III. He accused the king of, in an anonymous pamphlet, of having his foreign secretary of having an affair with King George's mother. He said that the king was full of malfeasance. King George is so angry that he issues a general warrant to find the author of this anonymous pamphlet. A general warrant doesn't particularly specify the place to be searched or the person or thing to be seized. And armed with this engine of tyranny, as Brandeis puts it, the agents of the crown break into the homes of lots of citizens, riffle through their desk drawers, read their private diaries, and eventually identify Wilkes as the author of this anonymous pamphlet, North Britain 45. Wilkes is charged with seditious libel, a crime, but he countersues on grounds of trespass. He says because the warrant was invalid, the crown agents are liable for trespassing on his home. He wins a ruinous verdict, £1,000, like a McDonald's coffee-like verdict for its day. But more important, said Brandeis, the principle established by the case was that the sacrosanct nature of private papers, that it was necessary for citizens to have places to record their intimate thoughts, both private diaries and their political dissent, in order to be full citizens and full human beings. So Brandeis took that principle and said, in the age of the wires, it's possible to invade far more privacy than it was necessary to do to break into someone's home in the age of Wilkes, because you can hear the conversations of people on both sides of the conversation. And then in this mind-blowing passage, Brandeis looks forward to the age of cyberspace. And he says, ways may someday be developed by which it's possible, without physically intruding into the home or tapping into wires, to extract secret papers from desk drawers and introduce them into court. Basically, he had a clip in his file about television, which he misunderstood as a kind of two-way thing. He anticipated Skype, essentially. And his law clerk made him take out the reference, but now Skype has made literal the possibility of two-way conversations where people can look at each other and invade far more privacy than Brandeis took for granted. So Brandeis...
We had that case about the Lower Merion School District, which had distributed computers.
Incredible case, where the computers were distributed, the school administrator turned them on and spied on the kids. So if you're going to focus on physical trespass, as Chief Justice Taft or even Justice Scalia would, you'd say the kids are out of luck, it was school property, too bad. Brandeis says absolutely not. We're focusing on this value, which is the necessity of a degree of anonymity in public and a place to record private thoughts. And it doesn't matter if the private diaries then are stored on third-party servers, or it doesn't matter if I'm ubiquitously recorded by cameras without trespass in public. That value of public anonymity was what the framers were trying to protect, regardless of the technology used to invade it. And that's why I think Brandeis could do it obviously far more eloquently, but it might not be that much more sophisticated than to say the framers of the Fourth Amendment believed that public anonymity was necessary for privacy and free expression. Technologies that invade it are unreasonable searches of our persons and of our electronic effects, period. I think that's what he would have said.
So halacha, when halachic decisors talk about applying ancient rules, my own sense is there's a degree of resistance to sort of raising the question to a level of abstraction, finding the real principle, the animating principle, and then applying the principle sort of with less constraint to the formalities of the precedent. The things that you discussed very dismissively is the wooden rely on some principle, on precedent. But I wonder if you would comment on the way the halakhic authorities would go about dealing with this need, I think, to raise the level of abstraction of a problem so that you could find the time, the reason, and then applying that principle to answer a halakhic question.
I think one of the, actually Rabbi Yaffe mentioned before that the Talmud, even when it talks about principles and cases, it will often raise a case which is non-existent, theoretical. It will often talk about something which seems very strange, and it does that in order to illustrate a principle. So it actually wants us to extract the principles. Rav Moshe Feinstein, who is one of the great decisors in Jewish law in the 20th century in New York, in the introduction to his responsa and responsa literature, in which he covers virtually every subject under the sun, medical ethics, social ethics, business issues, ATMs, surgery, transplants, nothing of which is mentioned in the Talmud explicitly of these subjects. But what he does is he goes straight back to the Talmud and extracts the principle, extracts the idea, and it's not a wooden precedent, but it's a living Torah which is designed using the partnership of the human mind with the Word of God. So that partnership comes out with a very beautiful application of those principles as handed down. It was just interesting. I was just in Linden, New Jersey for Shabbos, walked past a church, and they had the sign for the sermon was, why don't you turn off Facebook and look at the good book? God will never unlike you. Which I thought I liked it, and didn't get a chance to speak to the priest, but I was on the way to a scholar in residence. But when we look at the good book, so to speak, we look at the Torah, we see it as, we believe it to be something which is of eternal application and an eternal relevance. So that means a principle in the Torah and in the body of Jewish literature is not meant to be a one-time idea. It's not meant to be just that case. It's meant to be understood as something applicable to all times, all places, and all situations, which is actually what we're trying to do today, and what Rabbi Yaffe has done in his classes and the articles. And I think it does show the viability of the Torah, which we call often a Torat Chaim, which means a living Torah. If it's just kept in the ark, if it's just kept behind a glass case, that's not the Torah. The Torah is meant to be something which applies to our lives and in every conceivable situation.
Very brief. I would like to, with everyone's permission, just to bring it all together in the sense that we've been talking a lot about the fact, well, there's just a lot of information whether you're Google Glass, you're walking a lot. There's a lot of information that flows through the channels of information we have. We've been discussing, what can you acquire, what you can't acquire, but I think it's also true that we have to accept that we must deliberately ignore and fail to interpret. We must deliberately make ourselves oblivious to things that we know anyways. And all the issues we talked today address this. And we see this actually, a very beautiful talk by the Lubavitcher Rebbe on the story of Noah's drunkenness. Noah gets drunk, and what happens? Along comes his sons, Shem and Yaffe, the two older ones, who don't make fun of him. They come along, and it says they turned their faces back, but they did not see their father's nakedness. So the question is, if they didn't see their father's nakedness, if they turned their heads, of course they didn't see the father's nakedness. So the explanation is as follows. They turned their heads because he's their father, and you don't want to see this terrible sight. But on the other hand, they did not see their father's nakedness. They refused to interpret it. They refused to judge him. They refused to process the information because it wasn't their place to sit in judgment of their father, right after the flood and at such a time. I think that one of the key things the Torah tells us is that just because we have something doesn't mean we can tell it to someone else. And just because we are aware of things doesn't give us the right to judge another human being or affect the trajectory of their lives. Many things ought to be left to God.
On that wonderful note, I think we can bring the conference to a close. Thank you very much, ladies and gentlemen.
Where's the kipper of the Malam Fagils?
Often thought if everybody was entitled to a drink, this is Noah.
Yes, absolutely.
Thank you, Professor Rosen, Rabbi Yaffe, Rabbi Becher, and Jerome for absolutely a fabulous program. I really enjoyed it. Hope you all enjoyed it too. Just again, thank you, for hosting us over here. And we look forward to programs in the future as well.
Thank you. We look forward to future programs. And please, anyone who is not a member, join the National Constitution Center. Thank you very much.
And just one more thing. The attorneys amongst us who require the CLE credit, please give your CLE forms to the people as you're going out through the doorway. And also there is individual photographs of each one of you available as you walk out as well.